Welcome to the Dudeology Show, where real dudes discuss awesome stuff, killer gear, and cool stories. We're your hosts, Brandon Mosley and Chris Gambino. Make sure to follow us on Twitter, Instagram, and all the socials at Dudeology Show. Welcome to the Dudeology Studios with your professors of Dudeology. B, cash rules everything around me, money, and the Teddy Pendergrass, the podcast, the Mr. Gambino. Before we get any further, take a moment and click on subscribe. And once you do that, you have done your part in advancing the movement. That is the effort to encourage and inspire dudes to be better and do great things, ultimately making the world a better place. Now, this is our first in a recurring series here at the Dudeology Show, where we bring our resident legal analyst, Legal Bill, in the studio to answer all of your hypothetical legal questions. Good evening, Bill.
Good evening.
And Bill, if I'm not mistaken, it's nearly 2 decades of practicing the law.
Yes.
Nearly 2 decades. That is outstanding. So I'm just going to fire one from you right from the start.
That's why I'm here.
I will be running or working out or in the car, and I'll just hear like a song that just gets me fired up, and I'm like, dude, I want that to be like my intro music. I want that to be my walk-up music to the show. I mean, it can be like Ozzy, Crazy Train, or Motley Crue, Kickstart My Heart, or maybe some old gangster rap from like NWA or Tupac, and I really want to play it and get fired up. Why can't I play that on this show?
It's copyrighted. So once a song is complete, it's copyrighted by virtue of law. Now, one can file and should file a copyright with the U.S. Office of Copyright. Okay? But even prior to that, it's copyrighted by law. Okay.
So once somebody records something, it's theirs, like this intellectual, I guess, deal, property? Is that what would fall
Yes. Theoretically under the law, but someone else could come in and say, I did it first.
So what would happen if I did play a song? And what would the recourse be if whoever owns that?
So instead of the intro music that we have, that Flo has created on his own, we play, Ozzy Osbourne's Crazy Train. We get a cease and desist letter? What happens?
Well, assuming it's filed with the U.S. Office of Copyright, then Ozzy Osbourne or his company, or the company that owns it, would have the established record that they own it. Then they would file a lawsuit, but prior to that, they may file a cease and desist, telling you to stop playing it and perhaps to pay some sort of out-of-court settlement. If you refuse to, then they could take you to court as long as it's filed. So that's the distinction between filing with the U.S. Office of Copyright and not, okay, is that once you file with the U.S. Office of Copyright, you have the right to file a lawsuit. That's why
now you hear these podcasts and these other shows out there, they're taking a tiny little clip from a movie or from one of their favorite rock and roll songs. Is there anything under sort of fair use that maybe you can speak towards that would allow that, or are they just sort of playing with fire, hoping not to get a lawsuit?
Well, there could be multiple scenarios. You could have one scenario in which they have an agreement to use it, and they're paying money for it, or they just have an agreement without any sort of compensation. That's one example. Two, they just take the risk. So, for example, I'm sure it's not true here, but if no one's listening to this, you have zero audience, you can play music. People aren't going to hear it, right? People have to hear it.
Yeah.
So those would be the two, scenarios that I would analyze it under.
Yeah. So would they, and we're going to move on past this is kind of fascinating stuff. So basically, you have creative ownership of it. You create something, they file the patents, and it's theirs to use. And if someone were to use it, unless they paid some sort of royalty, some pre-agreed upon royalty, then it's breaking the law. It's illegal. Perfect.
Interesting. Okay. Yeah. Well, Legal Bill, before we get into fielding some of our questions from our listeners and some other stories and some things you've got for us, tell us about this killer beer that we're about to be drinking.
Lagunitas. So Lagunitas is a California beer. It's brewed in California, and the reason I love it is, one, I love IPA, and two, they moved to Chicago.
And you're from Chicago.
I'm from Chicago, so I love everything Chicago, just about, not everything.
Can we get a quick
most things?
Bill Schwartzky's The Bears.
Nice.
The Bears.
The Bears. Nice.
So they moved to Chicago. I love it, and I drink it.
So awesome. Petaluma, California, and Chicago, Illinois. Lagunitas IPA. Shall we, gentlemen?
Yeah, let's crack it open.
All right. Well, Legal Bill, let's crank these little toasts.
Cheers.
Cheers, guys. And let's get after it.
Okay. Real quick disclaimer. As a reminder to our listeners, we're going to discuss hypothetical legal scenarios and questions with Legal Bill. You should not take this as legal advice, and should go hire an attorney if you think you need one. In other words, the Dudeology show, nor legal bill, is liable. Let's get into this.
So by saying that, could anyone sue us?
Sure.
But we just gave the liability. It's like if I rent a boat and I sign that I accept the risk of whatever.
A different type of waiver of liability. It'd be unusual for someone to sue us here, to take my advice and to sue us for holding out as legal advice. Most waivers of liability, what you see is when you go rent a boat, right? You sign a waiver of liability saying if the boat company's negligent, you waive liability against them. That's typically not enforceable. It's enforceable, but it's not dispositive. So in the law, you say dispositive. What's that mean? It means it ends a lawsuit. Lawsuits go on and on and on, whether those exist or not. But if you're a business, you want to have it.
Okay.
It's still a defense, right? It's evidence of we took steps to notify and disclose to the consumer that there's these risks associated with this activity, and they've even agreed to waive negligence. Okay?
So I would almost, if I were trying to sue, and I let's say I rented a boat and I hurt myself, but even though I had signed assuming all the risk, the onus is almost on me to prove that maybe something wasn't covered in that liability waiver, or maybe because I'm signing that thing saying I agreed to all these terms.
Well, let's back up a little bit. So in the United States, we have 50 states, right?
Mm-hmm.
And we have tens of thousands of municipalities and counties, and we have the federal government. So every state's different how they treat waivers of liability. So a consumer-friendly state, like let's say California, is different than a business-friendly state than Texas. So they're going to interpret waivers of liability differently. Okay. And they're going to, favor one side or the other. In the state laws will be set up to favor one or the other. But to answer your question directly, just because there's a waiver of liability, somebody signs off on it, doesn't exempt the business from liability. You can still file a lawsuit.
Yeah, I do. But aren't some things don't some things come with, I guess, I don't know, you call an inherent risk? Like if I live on a golf course and somebody shanks a drive and it hits my window and breaks it, I mean, it's an inherent risk I'm taking by purchasing property on a golf course.
True.
So how is that interpreted in the legal system?
Well, that's a defense. So that's similar to going to a baseball game. So if you're in a baseball game, there's a foul ball, it hits you, it knocks you out. There's an assumption of risk defense, meaning the baseball team and the stadium and the venue will say, hey, you went to the baseball game, you know there's foul balls, you get hit in the head with a foul ball, right? Sure. Same thing on a golf course. Your window gets hit with a golf ball, window breaks, assumption of risk. Right? It's a defense, but it doesn't end the lawsuit. It doesn't prevent a lawsuit.
Sure. Pretty much anybody can sue anyone else for anything these days.
I mean, lawyers don't set up laws or statutes to reduce business.
Mm-hmm. Right. Sure.
Right? So you have to kind of operate on the basis that lawyers fill legislatures, they fill Congress, they fill city councils. Obviously, judges are lawyers. So the law is really set up for lawyers to do work.
So even if there's a disclaimer that's been given, or you've signed, or even if you say with all due respect before you curse someone out, you could still be sued.
You could still be sued.
I think
but you still want to have the disclaimer.
Absolutely.
I think it's important to have.
Absolutely.
Okay.
It at least protects you a little bit.
Yeah. And maybe it deters people from suing you.
Could. It's a defense.
Yeah, sure.
You say, look, you signed this.
All right. So the next question we got is something we're all kind of wondering about. A grand jury. So you hear that term and you're like, ooh, interesting. Well, I know I can get called to jury duty, but what is the grand jury and what kind of cases are brought before a grand jury?
So a grand jury is incorporated in the Fifth Amendment of the United States Constitution. Okay, so you see it much more in federal courts than you do state courts. Some states have grand juries, but it is historically was a Fifth Amendment right to a grand jury. And there's only one other country in the world that has grand juries, okay? And what a grand jury is for criminal trials, so not civil, not you're suing somebody for negligence, for criminal trials. It's for, historically, it's for infamous crimes, capital punishment. Now it's expanded beyond this. What a grand jury is, it's really a prosecutor's ability to present the evidence from the prosecutor's point of view. There is no defense counsel, and there is no defendant at a grand jury. So the prosecutor puts on his or her best case, and this grand jury is impaneled to review the evidence and to either indict or not. So in federal court, it's a step in most criminal cases, not civil, to get to the next step, which are charges.
Gotcha.
Can you get selected to be on a grand jury just like you can get selected for county jury duty?
Exactly. Now, the prosecutors are typically more sensitive to one's schedule. So if you're called to do civil duty in Duval County or St. Johns County, you're there, right?
Yeah.
Grand jury, prosecutors, one, they don't want to upset the grand jury because they're seeking indictments. So they want people who want to be there. So it's somewhat rigged for indictments. But it's also usually a longer period where someone agrees, like a retiree, to be on a grand jury or to be available for grand jury for a couple months.
When you hear, and this is interesting about like suing people and kind of getting to like the criminal side of things, we hear a lot of, well, if this person chooses, they can only get sued if someone chooses to press charges. Like, let's say you punch me in the face and I say, I don't want to press charges. You're being the assailant. Could you still be in legal trouble for assaulting me?
Yes, you could. So it's a false notion that the victim needs to press charges. Okay, that's kind of something used in the media, used in politics, and used in Hollywood. They refuse to press charges, right? Now, if a victim doesn't want to proceed with the case, it makes it more difficult for the prosecutor. He or she needs to think through, like, well, if I don't have someone who's willing to testify, am I really going to bring charges? But it doesn't foreclose the opportunity to bring charges, right?
Interesting. Interesting. Why can't people, or I guess there's this kind of misnomer, and I think we've all heard of these people. We refer to them as like jailhouse lawyers. I remember when I was in the Army, there's always these guys that are like, oh, do this, do that. They think like they always know the system, like better than like a professional or whoever does. And you always hear these things like, oh, if you work for the government, you can't sue the government. And I'm thinking like, yeah, but if I work for a company and I'm wrong, I feel like I have a case, I could probably sue my company. Why can't government employees sue the federal government?
They can, depending on the level of government. Remember, let's go back. There's 50 states. There's one federal government. And there's many, many municipalities and counties across the United States. These states, these municipalities, these counties have different rules and regulations and opportunities to sue. So some you cannot. Others you can. In Florida, an employee of a state agency can file suit for discrimination, as an example.
Okay.
So it just depends. There's different immunities depending on what state you're in, whether it's the federal government or state government, and the type of claim. Right? Now we have workers' compensation claims, which prevent in most states employees, whether private or public employers, from suing them because they're covered under the worker comp laws.
Interesting.
When you start getting into these conversations around, I think you had mentioned before, like the Fifth Amendment and the different amendments, I think something else that's probably misquoted a lot is, well, it's my First Amendment right, so I can basically say anything that I want on any platform to any person, regardless of how offensive or even, half-truth it may be. How does that apply, like First Amendment rights, when it comes to what you can say maybe in the workplace or maybe on Facebook or social media at different platforms?
Sure. So that's a great question, and I think it's often misunderstood. The First Amendment is fundamentally protecting individual rights to speak out against the government. So if you disagree with Donald Trump's policies, then you have a right to speak out against those policies without the government coming and saying you can't say that. Conversely, you can say, I disagree with Nancy Pelosi, the Speaker of the House, on these policy issues. You can speak out against that, okay? And that's protected under the First Amendment, freedom of speech rights. With this employer, it's not. With Facebook, you hear it all the time now saying, well, Facebook's controlling what people can post. You know what? They can.
So they're a private. So by me, I log in and do a Facebook account, and I put something on there that Facebook deems is
inappropriate
or disruptive, whatever. Yeah, inappropriate. They can censor it.
And that's according to their terms of service, right? Terms
Sure.
of use. and they can do whatever they want if you've agreed to those terms of use, essentially.
Exactly.
Well, kind of back to the waiver of liability.
Yeah.
It's somebody, you have to click accept. And it's really our responsibility to read all the fine print.
And I think that's where,
people are confused about that.
Moving on to that, though, in law, we accept all kinds of terms on the internet and on applications on our computers every single day. Would you say that everybody's pretty much breaking the law on any given point in some way on an internet terms of service?
Anybody but me.
Of course. Of course.
I mean, I think
Hypothetically.
Most of us, and of course you've read them all. We have not.
Well,
we just click accept.
Well, I knew somebody who had nude photos, right? And was a photographer.
Himself?
No, of others, but
okay.
they were, they consented to it.
Yeah.
And Facebook took those off. And he made an argument that I have my First Amendment rights of speech to put these photos up. And I told him, no, you don't. Facebook can decide if they want that up there or not. They probably have terms and conditions that they have this right to censor and to remove whatever they may find offensive. It's probably broad language. Okay? Right. Same thing with the employer, right? So you're employed by a supermarket, and the supermarket says, when you're on the job, we don't want you campaigning for a presidential candidate. We don't want you speaking out about politics, period. They can do that, right? They can't do that once you leave. They can't say, we're going to fire you, right, because you go support a particular candidate. But they have a right while you're on the job to censor what you say.
Well, let me ask you this. What about a situation where maybe it's a salaried employee, so there's not like the on-the-job is a little flexible. Could, if they said or did certain things that were maybe detrimental to the employer, so let's say they are the salaried employee, to your point, at the supermarket, and they were maybe a supermarket that didn't sell any organic food, and this person was posting on Facebook about only buy organic and the harm that non-organic food can do, knowing that their employer sells non-organic food. How does that kind of fall in? Is there a recourse by the employer then?
So that's not a First Amendment right, because you're not speaking out against the government. You're not speaking about a governmental issue, right? It's just a personal view. And that would depend on, you have to look at the policies of the company. Do the policies address that? Do they curtail what people can say or not say? Do they have unfettered rights? Is that exempt employee or salaried employee? Is that person at will?
Yeah.
So you could just term them without even saying this is the reason we're terming you. So there's a lot of factors.
You're starting to notice more and more these days, people are getting in trouble in their office and workplace for what they're posting on social media. And because it's so controversial at times, and some of it's leading up into them getting terminated. So that's starting to become a much bigger thing. I don't know if you are starting to see that as well as a trend.
Yeah, I have. And again, I don't think that's as much a First Amendment right as that is, is it wrongful termination? Are there legitimate bases for terminating? Do they have a contract? Don't they have a contract? What does the contract say? What are the policies of the company? Those type of issues.
So dudes out there, Legal Bill and the Dudeologists here, be careful what you're posting on social media.
Yeah, social media, as a rule of thumb, I think if you stick with things that you see on the Dudeology show and birthdays and pictures of your kids and stuff, I think that you'd probably be in pretty good shape.
Reposting the Dudeology show is probably one of the best things you can do on social media.
Absolutely. We'll make sure that we keep it employer-friendly on all of our...
And I've never been on Facebook. I don't have an account.
Oh. Probably one of the last people left on Earth without a Facebook
I'm a
account.
dinosaur.
Maybe.
So there's this term we've heard about called eminent domain. What is it?
Well, that's, again, another Fifth Amendment, right? So the Fifth Amendment, the United States Constitution.
That sounds like an important one.
It's a very important one.
A lot of people...
First one to learn about in law school.
Everyone's always pleading the Fifth.
Got the First, the Fourth, the Fifth, the 13th, the 14th, the 15th. Those are the big dogs. Okay. Those are the ones that are... super important. Other ones are too, but those are the biggies. So the Fifth Amendment covers eminent domain. So essentially what eminent domain is, the government comes in and takes private property for public use. And the Fifth Amendment of the Constitution allows that for just compensation and due process under the law. So the Fifth Amendment's all about due process. My Fifth Amendment right, if you're a criminal defendant, I have my Fifth Amendment right. A right to due process. Taking my property, right to due process, right? So eminent domain is essentially either a municipality, state, or federal. Again, all the levels of government come in and say, we need that property for public use. We're going to give you just compensation, and they need to afford you due process under the law.
And I think you hear some of this has come into play, and you think eminent domain, they're going to take all of your land and build a pipeline or something through it. But I think probably more common is, hey, we're going to widen this road, and it's going to take up 5 or 6 feet past maybe an easement that you have on your real estate. And I think people get kind of out of sorts about it because they're not really paying. You said I think compensation, just compensation. I think that's maybe where how much is 5 feet of your land really worth? It's probably worth less in the eyes of the government and maybe a little bit more in the eyes of you who may be losing your front yard. You touched on some criminal. You said some rights. We see on these cop shows that you have the right to remain silent. They're called the right
Miranda.
to
Miranda rights. Miranda v. Arizona.
So are those like? Because we see it on TV that those are like the first thing that happens as soon as the cops show up at your door. Is that a legal requirement that's like one of the first things that has to be disclosed before you enter discussions with the authorities?
So that's an interesting question in that the Miranda rights are required once the criminal defendant is in custody and the interrogation begins. Then they need to disclose the Miranda rights. Now, they don't have to do it verbatim like you hear on TV. It just essentially need to say you have a right to remain silent, you have a right to an attorney, right? You say those 4 or 5 elements you say. Once they're in custody and being interrogated. So what police officers will do is often ask questions. So you roll up to somebody, right, and they're being suspicious, and you say, hey, have you been drinking? Hey, have you done drugs, right? They're not in custody yet. So if someone said, you know what, I have drugs, right? Miranda is not going to protect them from that. But once a police officer says you're detained, then they need to disclose and say the Miranda rights.
So as a defense attorney, not that you are a defense attorney, but would you recommend that people say less than more?
Yes. I would say in
regardless of whether they're
a
guilty
euphemism would be shut up. Shut the F up, right?
Exactly. Yeah. You know what? I'm a big fan of the show, The First 48, and I am just so surprised at how many people don't ask for attorneys and how often they're either prosecuted or in trouble, even if they didn't do it, just for being there, and they talked and they never asked for an attorney. And I'm not saying they it's their personal right to do so, but it also says everything you say and do will be held against you, right?
Sure.
In a court of law. So, interesting.
And to that point, I had a criminal procedure professor in law school who told my class that their studies had been done that it was really your mafia, your mob criminal suspects who exercised that right. So even though Miranda rights are read, people, depending on their background, their educational level, are more or less likely to exercise them. Yeah. So in these shows, you may see a lot of folks not exercising them. And that doesn't necessarily, that's not necessarily inconsistent with what happens in the real world.
Yeah. And he was not referencing mafia because my last name is Gambino, obviously. Well,
yeah, the show will get shut down quicker than we had hoped for. Then I guess we'll find out there, Gambino.
Absolutely.
So and it's crazy too about these shows. It's also amazing that that the cases get solved into jury and convicted all within like a 58-minute segment. That's it's phenomenally.
And kudos to those police officers, right? Like that's awesome, and the prosecutors and everything when they are guilty. I mean that. It is really neat to be able to see that process work, right? Mm-hmm. And it's supposed to work that way to protect society, right? Mm-hmm. So one last question that we have that came in, and it talks about, people saying possession is 9/10 of the law. What does that mean, and is it enforceable?
Well, that's a Scottish expression, so it has some legs to it, some age to it. What that means essentially is that someone who's in possession of property is the likely actual owner of that property. So you're wearing your shirt, Chris, right? Because you're wearing your shirt, you have 9/10 possession. 90% likelihood you own that shirt.
I could have borrowed it.
So it's
for
an
random.
expression. It's not enforceable. It's an expression under the law. If you're driving a car, there's, 9/10 possession, presumption you own that car. Now, you may not, but that's a presumption. But it's not a legal term. You can't find it in a statute, in case law, or anything like that.
Well, again, jailhouse lawyers, you would think that you're just, I'm just going to take this weight and I'm going to hide it in my house for 7 years, which is, I don't even know if that's statute of limitations. This is, again, one of these terms that you hear. And then in 7 years and 1 day, I'm going to emerge with this said weight, and it will now be mine. And Chris won't be able, or the Dudeology show won't be able to take any recourse against me. Is that false?
Well, again, it depends state to state, right? We're back to that same analysis. But there's something under law called adverse possession, where someone can falsely come into possession of property, and as long as it's open and notorious, they may have a legal right to it. I would argue that if you have that in your closet, it's not open and notorious. Therefore, it would...
If he put it in his front yard as next to his yard gnome, then it's open.
If I painted it a different color so it didn't appear to look like the Dudeology show kettlebell, and I pretended that it wasn't, you are going to be a wealth of legal knowledge for this organization, for the Dudeology show. But what we really love to do here is highlight some cool stories as well. So we want to transition a little bit, and we just want you to entertain us now and tell us a pretty cool story. Maybe one of the craziest cases protecting, obviously, all parties involved. That you've ever been a part of?
Okay. That's a great question. I have a few that come to mind. One was probably the most odd and interesting. So I was a member of the federal bar in Chicago. As a member of the federal bar, you're required to do pro bono work. Required, right? So federal court sends you a case, you have an indigent client, you're required to represent them.
And did you have to do a certain amount of hours, like per month, or is just as
case.
needed? As case. Yeah.
As needed, as sent out. So I received this case from an inmate in Cook County who was convicted of murder and was awaiting transfer to the state penitentiary. A very sad case, very difficult background, gang member in Chicago. And while he was in the Cook County jail waiting transfer, he alleged that he was his civil rights were violated under Section 1983, which is a federal statute. He claimed that the prison guards came in and beat him up, and he was injured. So my client had a history of bad behavior with the prison guards at Cook County. It was written up multiple times. 3 weeks before the election of the incumbent sheriff of Cook County, he escaped.
Oh, wow.
He was a convicted murderer. He escaped, was found in Cicero, which is right next to, you should know Cicero. It's a big mob formerly. So he was found in Cicero, and they brought him in, and then he was in solitary confinement. So needless to say, there was, a bad relationship between my client and Cook County Jail. Mm-hmm. The incumbent sheriff goes down, loses in a re-election that most thought he would win. So, and most guards and people who worked under the sheriff liked him, respected him, so people were upset. So let's fast forward to the case I was assigned. My client is waiting for transfer to the state penitentiary. He's under solitary confinement. He cannot interact with the other prison population. He has his own times for free time. When he eats alone, etc., etc. So the night before he was transferred out, they brought him in the evening, about 9 or 10 at night, to have dinner, to be in the rec room, and to take a shower and go to bed. And he was in this prison cell. A bunch of cells were kind of facing the rec area. And there was a prison guard station looking into this area. So by his testimony, nobody else's, he walks in, he wants to take a shower, the showers are broken. He tries to elicit the attention of the guard in what he called the bubble, and he alleges that the guard ignored him. So what he did was, by his own testimony, is he took some cardboard and some pencil and put it into a light socket, started the cardboard on fire, held it up to the sprinklers, started the sprinklers.
This is so he could take a shower.
So he could take a shower.
So the guy's going to the state pen tomorrow, the next day, and he wants a really good shower. He already had his good meal, and then this is extreme. He really wanted the shower.
Really wanted the shower.
shower.
So he showered. He did it, he kept his shorts on, but he showered in front of all the other prisoners.
Our alarms were probably going off.
Alarms going off, sprinklers coming down, guards come in, obviously, rightfully so, armed up. Fire department's trying to get in. And before they even get in, he took feces, by his own testimony. He took feces out of the toilet and flicked the feces on the bubble where the guard is. So now there's feces floating around the water.
Ugh.
So this was this while he's trying to get attention? He's like, I'm going to throw some feces because they won't pay attention. Then I'm going to shower off.
Euphemistically,
sure. Okay.
Sending a message.
Okay. I didn't know you could start a fire with a pencil and a piece of cardboard and a light socket. Not to go too far down that.
So
we're gonna have to try that.
Creative.
A dude hack. We're gonna dude hack that one.
So he alleges that the guards came in and took him into an empty cell and beat him up. Guards, their position was he slipped and fell on the water. I don't know. I wasn't there. So he was transferred down to the state penitentiary, actually in the same penitentiary that Harrison Ford in The Fugitive. Okay. When he escaped, remember that movie?
Yes.
When he escaped, it was
Chicago physician wrongfully accused of murdering his wife.
And this was the highest security penitentiary in Illinois. And essentially, I went from Chicago, I flew to St. Louis, and took a 2-hour drive to somewhere. I don't even know where it was. Right? Wooded, rivers. I go in this penitentiary, and we took his deposition. Right? So he gave his testimony. I was there with Nick Skoufis, who was a Chicago prosecutor. He was defending the guards. He was a great guy. And then we came back, and he basically said, Bill, come on, there's not a case here. Right? I get a letter in the mail from my client's neighbor, and they're in the same gang together, and he wrote an affidavit that was verbatim what my client said happened. Now go imagine that.
Okay. Huh. Okay. So neighbor meaning like the next jail cell over?
Yeah,
or neighbor
he was there that same day for a different murder conviction.
Sure, and so he's kind of like, if I can imagine this, like cell block. He's like watching a TV show. He's watching the guy down here try to get their attention, according to him, and he's watching the turd maybe fly through the air and smack on the window or something, right? And then the water coming down. So he's kind of like, buddy, just watching it.
It's the best thing I've seen all week.
So he proactively sends you this letter, and you just get this letter, and you say,
I didn't solicit it.
Okay.
It came to me. So I called Nick Skoufis up and said, Nick, I have this letter. I have to send it to you. I sent it to him. Nick's position was, come on, Bill. This is exactly what your client said.
Probably some sort of corroborated.
It was his theory, his position. I said, well, I have an ethical duty. I've been assigned this case from the federal courts. I'm required to do it. I have an ethical duty to disclose this letter to you. So I went back to the prison, and in the middle of nowhere, I shouldn't say that, somewhere, but I don't know where it was, and took his friend's deposition. The case finally settled prior to trial. Now, we had to arrange for his travel up to Chicago, which required a lot of police officers and guards and things like that. But it was a crazy case because I didn't do criminal law. So, and it wasn't 1983 action in civil rights, but you're still dealing with all these criminal issues, going into prisons, things like that.
So in a case like that, so the guy's been convicted of the homicide. So he's going, and you say they settled the case. What kind of restitution do you get if you're already going to go to prison on a sentence, but you're suing them? Is that a civil?
It's a civil. It's a financial. In most states, including Illinois has a debtor statute where it's capped. So basically, the state has a statute that says a debtor, criminal debtor or some other type of debtor, is entitled to a certain amount of money up to a point, and then after that, it goes to the state because the state's paying for them in some fashion. So it's a financial settlement.
Okay, and it's interesting because you touched on something that we kind of, again, we get a lot of our legal, I guess, behind the scenes from watching TV or movies.
Yeah.
But you're having this conversation with the prosecutor, and prosecutors and defenders typically pretty cordial. You think they're going to be like hammering at each other and they hate each other's guts, but you're just having a conversation with this guy. Like, you don't have a case? He's like, actually, I do. Or you're like, actually, I think I do. And is there a lot of that back and forth kind of behind the scenes when lawyers get together?
It depends. I think a lot of lawyers try to be cordial. We were cordial, I think, in part because I was assigned the case, right? I didn't pick this case up. I didn't ask for it. It was something I had to do. So we kind of had this understanding that I'm doing what I need to do ethically. But, I would say that it really depends on the lawyers. It also depends on the jurisdiction. So the bigger the cities, the more difficult the attorneys are personality-wise, if you're just going to generalize. So when I would have cases, most of my cases were in Chicago, like the opposing counsel could be tough.
Mm-hmm.
The farther I got out, suburbs, collar counties, rural counties, the lawyers tend to be friendlier. But a lot of it depends on how well you know the person.
Now, did the criminal request an attorney pro bono, or is this a case where it's under Miranda, where if you can't afford an attorney, one will be, assigned to you by the state?
You mean mandamus?
Sure. That too.
Yeah. So they file a case, and they either can agree to pay for it or check a box saying they can't afford it.
And is that in Chicago where they would assign something pro bono, like to your firm, or is it just there are state attorneys?
Well, this was federal. This was the federal courts, so this would be anywhere in the United States.
Okay.
I happen to be in Chicago, but if you're a member of the federal bar, then they can assign you cases.
That's some fascinating stuff. It really is. You think, I do think, like, legally and lawyers, obviously everyone's got probably a lawyer joke, and you get kind of like this bad rap of this ambulance chasing, but knowing the majority probably aren't like that, and it's really cool. And just getting to learn about some of that cool story, and then some of the other just legal things that would drive around and just wonder about throughout the day. So we're going to look forward to having you. Definitely come back on the show. I know I don't want your beer to get too warm, so we're going to let you finish that and maybe crack another one post-show and discuss some more off-air legal issues. But thank you again, Legal Bill, for throwing down some legal knowledge. We look forward to having you back on the show. Definitely leaving some good legal good action. So make sure to check out all of our past episodes and subscribe on whatever you listen to your podcast for the full video experience. Make sure to check us out on YouTube. And from the studios and on behalf of all dudes getting after it out there, thanks for listening. Thanks for listening to The Dudeology Show, the place for cool stories, killer gear, and awesome stuff. Make sure to subscribe, like, and share on all your socials at Dudeology Show.